Hello guys, this is your guy Desmond on Legal Matters. Legal Matters is the only channel that is here to create awareness of the law. Now, today we are going to look at the Nigerian rape case between Busola Dakolo and Biodun Fatoyinbo. Now, but before we go into the legal perspective, we would like to state here that people have not been looking at this case from the objective point of view. Yes, this case is supposed to look at it objectively because this is the same way the court is going to look at it. Just like how Daddy Free said, none of us was there when it happened. So we only have to look at it objectively. We are not saying that it happened or it didn't happen. We are saying that the chances have to be 50-50 because as of now, there's no concrete evidence that actually points at the person that is being accused. So we look at it objectively and forget to put any emotions, apply sentiment or family ties. We look at it objectively. That is how the court is going to look at it. Remember, the only purpose of the court is to test and to demonstrate evidence. The court relies solely on the evidence that is presented before it by the parties through their lawyers. So we have to look at issues like this objectively, especially when they have a legal implication. We don't have to talk anyhow because everything we say may have a legal effect. Thank you. So let's look at the legal aspect of the particular case. As we all know, the legal issue here is rape. And in Nigeria, rape is looked at under two different laws. The Nigerian Penal Code, which is applicable in the northern part of Nigeria, and the Criminal Code Cap C 38, Laws of the Federation 2004. However, the one that is directly applicable to this particular case at hand is the Criminal Code Cap C 38, Laws of the Federation 2004. Note that there may be other laws which are applicable to this particular case, but the one that is most relevant to this case is the Criminal Code Cap C 38, Laws of the Federation 2004. Now, let's look further and know what this law says about rape. We can see here that under the Criminal Code of Nigeria, rape is defined as having unlawful carnal knowledge of a woman or girl without her consent, or with her consent if the consent is obtained by force, or by means of threat or intimidation of any kind, or by fear of harm, or by means of false acts, or in case of a married woman, by impersonating her husband. That is, somebody can make the woman to believe that it is a husband. Yes, there are people who behave like that, probably in the night or something. There are instances where you can manipulate over the woman to make you believe that you are the husband. So it all happens. The law took this into consideration before bringing out this particular law. Now, we see that this offense is punishable by imprisonment for life, with or without caning. Yes. So understand that these are the instances where you can consider that you actually raped somebody in Nigeria. Yes. That means without the person's consent, or while putting the person in fear of death or hurt, misrepresenting as to the husband of the woman, having carnal knowledge of a girl under the age of 14, even if she gives you consent, it is considered void, null and void, because the girl is too small to understand, first of all, the nature of the act, talk less of giving real consent, but the law can actually look at it as consent. So it's still rape. Now, having carnal knowledge of a girl with unsound mind, any person with an unsound mind is incapable of giving consent because, first of all, a person cannot decipher and understand the nature of the act that she or she is consenting to. So you cannot actually say that the person with unsound mind gave you consent. It is unheard of. So it's still considered rape. Now, let's look at how rape is proven in Nigeria. Under this section, we're going to look at the burden of proof as well as the standard of proof. It's somewhere that we'll know whether Busola can actually prove her case against Biodun. Let's look at the burden of proof. Now, it is strict law that in criminal cases, the burden of proof is entirely on the prosecution to prove the guilt of the defendant. This burden does not shift if the plaintiff must secure a conviction. This is because there is a presumption of innocence in favor of the defendant, as he has no obligation in law to prove his or her innocence. The duty is squarely on the shoulders of the plaintiff to prove all the ingredients of the offense so as to secure a conviction. In the case of Uboji versus the state, It was held that the law is well settled that the prosecution always has the burden to prove the commission of an offense. This tallies with the honored principle of law, which states that whoever accepts must prove. Therefore, in criminal cases, the law places the burden of proof on the prosecution, and the standard of proof for such cases is proof beyond reasonable doubt, in order to establish that the accused person actually committed the offense or the wrongful act. Now let's look at the standard of proof. It is also tried law that the standard of proof in criminal proceedings is proof beyond reasonable doubt, but not proof beyond the shadow of a doubt. Now, in criminal proceedings, the onus is always on the prosecution to establish the guilt of the accused beyond reasonable doubt, and the prosecution would readily achieve this result by ensuring that all the necessary and vital ingredients of the charge are proven by evidence. It must be noted, however, that under the Nigerian system of criminal justice, the accused person is presumed innocent until proven guilty, and the burden of proof is always on the prosecution. However, where the defendant makes an assertion over a fact in a criminal matter, the burden is on him to prove that particular fact. As we all know, whoever alleges is under a legal obligation to prove. Now, even though the standard of proof is proof beyond reasonable doubt, this does not necessarily mean beyond all doubt or beyond a shadow of a doubt, as there cannot probably be any proof that can be beyond all doubt or a shadow of doubt. Before it can be said that the prosecution has proven a case beyond reasonable doubt, every ingredient of the crime must be established. In other words, if one element is left out, then there is no proof beyond reasonable doubt. Now, let's look at the Supreme Court case of a carrier versus the state, where it was affirmed that by the use of the phrase proof beyond reasonable doubt, it presupposes that all the ingredients establishing a crime must be proved to such a degree that there will be no question or stone left unturned as to the certainty that the accused person actually committed the crime for which he or she is being accused of. Now, the culpability of the accused should not be in any shadow of a doubt, but a clear focus of attention. That means from all the evidence adduced before the court, if you look left, right, front, back, and center, everything will point straight to the accused that he committed the crime. This is what we mean by that. Now, for such proof to sustain a conviction, it must end the credibility of eyewitnesses' testimonies, if any, who must give a first-hand account of facts which are within their personal knowledge. In this case, there is no person that can give a first-hand account because there is no eyewitness to this particular issue. Yes, and the law says that any other source of information will be considered as hearsay evidence, which is inadmissible before the law court. So we will see that this case will be very difficult to prove because we don't have any eyewitness. Neither do we have medical evidence. There's another thing too. The million-dollar question here is, can this case be proven? Can this rape issue be proven? Yes, from the point of view of legal matters, yes, this case can be proven. Yes, in any of these two ways. One, it could be by confession or corroboration. Yes, if Biodun decides to confess and redeem himself, he's a man of God. If he's truly a man of God, he can decide to confess if he actually did it and redeem himself so that at least he may seek forgiveness in the face of the Lord and become a true man of God back. If not, Busola could look for one of those people, yes, one of the church members that were present when he confessed to them, but he actually did it and he doesn't know what came over him. So if this is true, then some of those people that were present during that confession could come up and testify. This could be another good way. If not, I think the only way is to establish a pattern. Yes, as a second option for establishing a pattern. If there are other victims claiming that we were violated sexually by Biodun, they will also come up and meet Busola. That way, the court can establish that this is a habitual something, it's a regularity, a pattern. It's something that he does. So it will be easier for Busola and the other victims to get a legal redress for this issue. This is how we think this case can be proven. What is the best way forward for this case? Now, this is the opinion of legal matters. The best way forward is to look for other victims sexually abused by Biodun so as to establish a pattern. This is the best way forward for this case. Now, why do we say this? This is because proving the case will be very difficult due to the lack of substantial evidence. And the case can eventually die a natural death, just like most of the cases in Nigeria. More to that, Nigerian law seems to be very lenient with rapists. Let's not forget that. Nigerian law seems to favor rapists. For the offense of rape to be proven in Nigeria, there must be corroborative evidence, which usually comes from eyewitnesses or medical evidence. As regards eyewitnesses corroboration, the law requires that such witnesses must have witnessed the actual penetration of vagina or the victim's vagina. How this is possible, practically speaking, at all times, defeats my wildest imagination. Most often than not, sex offenders will not undertake the abominable act in a place easily accessible to members of the public, and there's always a possibility that before any eyewitness finally reaches a rape scene, the offender would have disengaged from the act, which ultimately means that rape as a criminal offense cannot be established with a lesser offense of attempted rape in some cases. No, so we see that is how the case is. Now, secondly, the law requires that there must be penetration of vagina, no matter how slight this is. This in itself is a laudable idea, because modern realities have shown us that it is not only the vagina that can be penetrated or defied. These and other factors account for the low rate of rape prosecution cases in Nigeria. Let's look at other reasons. Yes, why Nigerian rape cases are not being prosecuted in Nigeria. Let's look at them. Now, talking about some of the factors that account for the low rate of rape prosecution cases in Nigeria. Let's look at it. Now, this is one, the inability of rape victims to report cases to the police. This can be seen from the shame or neglect shown toward rape victims in Nigeria by family and friends. It ranges from openly mocking the victims to being neglected by close family members and friends. In some cultures, some are even seen as having brought shame and dishonor to the family. Another one is that there's a general lack of support from care agencies of government, which should not ordinarily encourage these victims, but also re-engineer a system of reintegration of victims into the society. Considering the statistics of decided cases on rape at the Supreme Court and the Court of Appeal, a cursory look shows that most reported instances of rape are from underage children who do not usually understand the very nature of the offense. Most adults rather choose to suffer in pain and anguish due to the social stigma attached to this particular rape issue. So it is an unbearable something for women, and we should condemn it in all measures. Now let's go to the second one. Lack of proper investigation. We all know that there's a general apathy on the part of the police institution in Africa in general, not only in Nigeria. A typical example would be that of a victim approaching a police station and the police officers insist on laying the complaint over the counter without trying to conceal her identity or guarantee her privacy, or possibly request information that is not central to the genuine complaint. Did it enter? Did you enjoy it? So kind of foolish kind of questions. We really have to do something about this issue. Now, apart from the delay in commencing investigation, the police institution is not adequately equipped with both human and material resources to effectively investigate rape cases. There is a lack of specialized training for police officers in handling these cases or in providing support for the victims. Furthermore, forensic identification of suspects cannot be effectively carried out. The use of biological evidence such as blood, semen, saliva, vaginal epithelial cells, etc. is totally lacking. In Africa in general, not only in Nigeria. Yes, there is a serious doubt as to the existence of a fundamental forensic crime laboratory in Nigeria. Even in Cameroon, we don't have it. So we have a lot of problems in Africa. Yes, we have a lot of problems. So we shouldn't take this kind of issues lightly, like seriously. Yes. weak legal sanctions, and enforcement. Now, this point was brought up by Senator Helen when she moved a motion to protect infants and minors from the cruelty of sexual abuses and rape. Now, the former Senate President, David Mark, retorted that we must ensure that maximum sanctions are meted out to culprits of rape and sexual abuses. This is because it is not just a matter of ensuring maximum punishment, but a matter of enforcing the punishment in a very firm and decisive manner. Yeah. Now, the police authorities should courageously investigate and recommend for prosecution the alleged offenders. The judiciary also should not shy away from handing out maximum punishment when the occasion demands to sex offenders. This will serve as a deterrent to other members of the public. And I think this will go a long way to reduce rape cases in Nigeria and Africa in general. Thank you for watching. Yeah. Don't forget to press the subscription button to stay connected with us and to click the notification button and be notified each time we upload a new video. This is Legal Matters, and Legal Matters is here to create awareness of the law. It's your guy, Desmond. Bye. See you in our next video.